Okay. This is the people of the state of Michigan versus Christopher Eugene Payne, case 2356930. Mr. Payne is charged with count 1, controlled substances, possession, cocaine, heroin, or another narcotic less than 25 grams. Count 2, weapons carried concealed. Count 3, weapons, firearms, possession by a felon. Count 4, weapons, felony firearms, second offense notice. Count 5, weapons, felony firearms, second offense notice. With an habitual offender, fourth offense notice set for an exam today at 9:30. Appearances?
Edwin Sawaki, P54828, appearing on behalf of the people.
Good morning, Your Honor. If it pleases the court, Attorney Andrea Fanning, P42853, appearing with my client, Mr. Christopher Payne. Mr. Payne, can you unmute yourself and state your name for the record?
Christopher Payne.
Thank you. Your Honor, today is the date time scheduled for exam. I, of course, was on my way downtown, but after discussing this matter with my client, I've advised him of the purpose of the preliminary exam, mainly that the assistant prosecutor would have to prove probable cause that these crimes were committed by him in his jurisdiction. After doing that, he has advised me that he wishes to waive his right to a preliminary exam with the understanding that this matter will be filed over to circuit court for further proceedings.
Okay, Mr. Payne, is that correct?
Yes, ma'am.
Did anyone force you or threaten you to waive your exam today?
No.
Did anyone promise you anything?
No.
Any objection from the people?
No objection, Your Honor.
Thank you. Just going through that information for me. So I will have you bound over, Mr. Payne. I find your waiver to be freely, understandingly, and voluntarily given. Your arraignment information date will be June 16th at 9:00 a.m. Frank Murphy Hall of Justice. Bond is continued. Anything else from either party?
No, Your Honor.
No, thank you. Thank you. Have a wonderful day.
Thank you. You too. You're all set, Mr. Payne. You can walk off.
Okay, thank you.
Thank you.
Oh, one more thing. Attorney Payne, I'm sorry. Attorney Fanning and Mr. Payne, do I have your permission both to sign the waiver form since you are both virtual?
Yes, Your
Yes.
Honor. Thank you so much. Thank you.
Okay. Have a
Bye-bye.
good weekend.
You too. Bye-bye.
So the gentleman in the Wayne County Jail, can you state your name, please?
Jonathan Williams.
Thank you. Good morning.
Good morning, Madam Clerk. I'm on Perry Williams. I believe he may be in the waiting room at this time. This is Attorney Carolyn Marsh.
We don't have anybody in the waiting room.
Judge, it's Williams with Ron Hadid.
I'm sorry, your audio broke up, Attorney Irwin.
I'm on Donovan Williams. He's in the jail. Hadid is aboard by Zoom.
Do you want to speak to him in the breakout room before we go on the record?
I was asking for a breakout room with Mr. Williams.
Right, okay. It's a breakout room with your lawyer, so you all can speak freely. Private. The gentleman with the Samsung device, unidentified, state your name, please, with the black shirt on.
Perry Williams.
Yes, Your Honor, that's my client.
Got it, okay. Good morning.
Got him on.
Okay, Ready on Perry Williams?
Yes.
Excuse me, this is case 2355876, the people of the state of Michigan versus Perry Jerome Williams, charged with count 1, weapons, firearms, possession by felon, count 2, weapons, carrying concealed, count 3 and 4, police officer assaulting, resisting, and or obstructing, count 5, and count 6, and count 7, weapons, felony firearms, second offense, and a habitual offender, fourth offense, no, except for a probable cause conference appearances.
Edwards Walker, P5482, appearing on behalf of the people.
Good morning, Your Honor. Carolyn Chapman Marsh, P31887, on behalf of Mr. Williams, who is appearing via Zoom. We have no objections to proceeding via Zoom for purposes of today's hearing.
And Mr. Williams, can you state your full name for the record, please?
Perry Jerome Williams.
Okay, Attorney Marsh, do you have discovery?
I do have discovery, Your Honor, and I'm requesting an in-person exam date at this time.
Okay, let's see, the date I have here is set for June 9th. Let's see.
That's a good date, Judge.
Okay. About 9:30?
Could I possibly have the 10 o'clock slot if you have it, Judge, or a little later?
10 o'clock works.
Okay, that's good.
All right, so Mr. Williams, your exam has been set for an in-person preliminary examination at 36th District Court for June 9th at 10 o'clock a.m. You understand that?
Yes, ma'am.
Okay, anything else from either party?
No, Your Honor.
Okay.
No, Your Honor, thank you. Everyone have a good weekend. Thank you very much. You can sign off, Mr. Williams.
Okay.
Attorney
Judge
Hamilton.
Donovan Williams is ready.
Okay, let me just check with a couple of people. Attorney Hamilton, which case are you on?
Yes, I'm here for Samuel Parker.
Samuel Parker, okay. He's not checked in, but I'll let you know when he is, or let me know when you're ready to call the case.
Okay, yeah, let me see. I don't actually have a phone number for him, but give me a moment. Let me see.
Okay. Okay, Donovan Williams.
Ready, Your Honor.
Okay, this is people of the state of Michigan versus Donovan Larry Williams, 2357011. Mr. Williams is charged with 1 count of driving, intimidating, and or interfering with a criminal case punishable by more than 10 years. And count 2, obstruction of justice, set for a probable cause conference. Appearances?
Good morning, Your Honor, to staff. Rana Hadid on behalf of the people, P62243.
Good morning, Your Honor. Sally Irwin on behalf of Donovan Williams. I am 32405.
Mr. Williams, can you state your full name for the record, please?
Donovan Larry Williams.
Thank you. Good morning. Good morning.
Judge, I've discussed this matter with Mr. Williams. He is elected to waive his preliminary examination and be bound over to Frank Murphy.
Any objection from the people?
No, Your Honor.
Okay. Mr. Williams, I'm going to ask you a series of questions. If you can't hear me or if you don't understand me, let me know, okay?
Okay.
Is it your wish to waive your preliminary exam today?
Yes.
You understand that you have a statutory right to a preliminary exam?
Yes.
And that if you were to demand that exam, the people would have to show at the probable cause standard, which is the lower standard in criminal law, but still a standard, that those 2 charges I read off were committed in Detroit and that you probably committed those crimes. Do you understand that?
Yes.
And then by waiving your exam, the people do not have to show any evidence or present anything at the probable cause standard. Understood?
Yes.
You also understand that you are not giving up your right to trial?
Yes.
And knowing all of that information, do you still wish to waive your exam?
Yes.
Did anyone force you or threaten you to waive your exam?
No.
Did anyone promise you anything?
No.
Okay, I find your waiver to be freely, understandingly, and voluntarily given. Mr. Williams, since you're in custody, your arraignment on the information date will be 1 week from today, June 9th at 9:00 a.m. Frank Murphy College Justice. Attorney
Judge,
Irwin?
may I? Oh, yes, I was going to request a DSU, Your Honor.
Okay, I will order DSU. Do I have your permission, Attorney Irwin and Mr. Williams, to sign your names on the waiver form since you all are virtual?
Yes, Your Honor.
Mr. Williams?
Yes, Your Honor.
Okay, anything else from either party?
Nothing further.
In the breakout room?
Attorney Irwin,
Yes, Your Honor.
he wants to go back into a breakout room to speak to you, okay?
Okay,
All right, we're off the record. I'll put you into the breakout room.
Hello. Good morning, Judge.
Attorney Medley, good morning.
Good morning, Your Honor. I'm sorry, Judge. I believe I see my client now. Is it possible to have a breakout with my client?
Sure. Mr. Jones, I'm putting you to a breakout room with your lawyer. Make sure you unmute your device so you can speak to them, so he can hear you.
Okay.
Davenport, good morning. Attorney Davenport, are you ready?
Yes, my apologies, Judge. I just got caught in on another courtroom. Can I give it 1 second, please?
All right.
Good morning, Madam Clerk.
What case are you on? Oh, you're on Miss Motley Street. I had you checked in, Miss Barrage.
Yeah, we're just checking in for discovery. I'm not sure if my client is going to check in, but thank you.
Okay, after I call, this one case. Actually, we're waiting, so I can call yours. Let's see. Motley Street. Case 2356688, people of the state of Michigan versus Tasia and John Motley Street. Charged with one count of police officer assaulting, resisting, and obstructing. Set for a probable cause conference today. Appearances.
Edwin Milwaukee, P54828.
Good morning, Attorney CR438 appearing on behalf of Mrs. Mobley Street.
And we are waiving your client's presence today, correct?
Yes, Your Honor. For the purposes of this PCC, we request to waive my client's presence to discuss the discovery issue.
Okay, were you able to upload the discovery?
I haven't received, are you asking me or the prosecutor? I'm sorry.
Well, I guess I'm sorry, with the prosecutor.
Yeah, it was sent, May 30th.
I'm sorry, could you repeat that? You said it was sent out?
Yes, on May 30th.
Is there a way that that link could be resent? Because I haven't received nothing, and that was the issue when we were here.
Yeah, we can reset that.
I thought the issue was that it couldn't be uploaded. That's what I have.
That too is that as well. The OIC said that no matter how many times he tried to upload it, it wouldn't upload to the link. But he had the body worn camera on his desktop downloaded.
Okay.
Oh, yeah.
The OIC was able to upload it shortly after the exam.
Okay. Okay, Ms. Farage, I don't know if you heard that, Mr. Kirker said the OIC was able to upload the information or the discovery, so I will, Mr. Sawaki is going to resend it.
Okay, thank you.
Okay, so now can we set another exam date?
Yes.
We can do 1 week from today, June 9th. At 10 o'clock.
Your Honor, I'm gonna be on floor duty in Frank Murphy. I won't be available at that day.
Okay. How about Monday at 9:30? I'm sorry, Monday, June 12th at 9:30.
That works for the defense.
Okay. All right, so it's been set, and for some reason, if the discovery is still an issue, just log on early in the morning and address it on the record.
Thank you. You said 9:30, correct?
Yes.
Thank you so much.
Everyone, have a good weekend.
You too. Bye-bye.
Oh, yeah, I was like, oh, come on, we can't get it on that.
Attorney Mezzi, are you ready on your case?
I am, Your Honor.
Okay, Attorney
I don't-
Stalin.
I don't see my client though.
I'm bringing him out the breakout
Okay.
room.
Thank you, Judge.
Attorney Stalin, we're getting ready to go on the record on one case. You need to speak to your client in the breakout room before your case is called. The people of the state of Michigan versus Gregory Deshaun Jones, case 2357045. Mr. Jones is charged with count 1, weapons carrying concealed, count 2, weapons, firearms, possession by felon, count 3, weapons, firearms with an habitual offender, fourth offense notice, set for a probable cause conference today. Appearances.
Edwin Sawaki, P54828, appearing on behalf of the people.
Good morning, Your Honor. Romy Messi, P68245 on behalf of Gregory Jones. Your Honor, he consents to appear by Zoom.
Mr. Jones, can you state your full name for the record, please?
Gregory Deshaun Jones.
You and Attorney Mezzi, do you have discovery?
Your Honor, I have a discovery. I'm just trying to get the digital going. And I made contact with my client now. He had a number, his mother's number, but now he's given me a direct number with him. If we can maybe adjourn the probable cause conference a couple weeks for me to be able to get the digital going and then review that with my client. And then hopefully we'll know whether we're gonna need to hold this or not.
A couple weeks is a little far out, Attorney Mezzi. I can give you a week.
Can you do a week? I can do a week, Judge.
Can you do June 9th?
Yes.
Let's do 8:30 or 9 o'clock.
8:30 or not, 8:30 is good with me even.
Okay, 8:30.
All right.
Mr. We're coming back on the 9th for another probable cause conference to discuss any discovery issues and to possibly set your exam date. You do not have to appear in person, you can still log on from Zoom, okay?
Okay,
All right, Mr. Jones. Thank you, Your Honor.
You're welcome.
Have a good weekend.
Thanks.
You're all set, Mr. Jones.
okay.
Attorney Sallin?
Yes, Your Honor. We are all ready. This is going to be a waiver, Judge.
Okay. The people of the state of Michigan versus Christopher Casimir Rock, case 2357027. Mr. Rock is charged with 1 count of controlled substances, possession of cocaine, heroin, or another narcotic less than 25 grams, with the habitual offender second offense notice. Set for a probable cause conference today. Appearances.
Edwin Zawaki, P5482A, appearing on behalf of the people.
And good morning, Your Honor. Alvin Sallin, P23797, on behalf of Mr. Brock, who appears by Zoom. Mr. Brock, please identify yourself for this record.
My name's Christopher Casimir Brock.
Thank you. Your Honor, I have explained to my client the nature and purposes of a preliminary examination. He understands that at this stage, the people have to prove by a probable cause standard that he committed the crime charged in the complaint within the jurisdiction of this court and probable cause to believe he committed that crime. With that understanding, he wishes to waive his rights to a preliminary exam. He fully understands this matter will go to circuit court for final resolution. There's been no threats or promises given to Mr. Brock to secure the waiver.
Okay, Mr. Brock, is all of that correct?
Yes, Your Honor.
Okay, any objection from the people?
No objection, Your Honor.
Okay, I find your waiver to be freely, understandingly, and voluntarily given. So, Mr. Brock, your arraignment on the information date will be June 16th, 2 weeks from today at 9:05 a.m. Frank Murphy Hall of Justice, okay?
Thank you, Your Honor.
Thank you, Judge. You have a good weekend.
You too. And Mr. Brock and Attorney Sallin, do I have both of your permission to sign the waiver form since we're both virtual today?
You do, Your Honor.
Okay. Well, have a good weekend.
Thank you, Judge. You may leave, Mr. Brock.
All right, thank you.
Judge, I'm all finished. I'm sorry about that.
Okay.
All right, I'm out of here.
Okay, we are on the record as the people of the state of Michigan versus Patricia Torres Riddick, 2356933. Ms. Riddick is charged with count 1, controlled substance, delivery, manufacture of cocaine, heroin, or another narcotic less than 50 grams. Count 2, controlled substance, possession, cocaine, heroin, or another narcotic less than 25 grams, except for a probable cause conference today. Appearances.
Good morning, Your Honor. Dean Grand, P51260, Assistant Attorney General on behalf of the people.
Good morning, Judge, to you and your staff. May I please this honorable court, Justina Shabazz Davenport, P number 82743, appearing on behalf of Ms. Patricia Torres Riddick, who also appears by way of Zoom.
Ms. Torres Riddick, can you state your full name for the record, please? Okay, you have to unmute your device. Try it one more time after you unmute.
Renee Torres Riddick.
Thank you. Okay, Attorney Davenport, do you have discovery?
Yes, Judge, I actually picked up all of the discovery because it was not digital. I have that. I picked it up on Tuesday. I have not had an opportunity to review it with my client as I just with Ms. Torres Riddick by phone on yesterday. I am asking Judge at this time either for a continuance of the
of the PCC, or I would ask for an exam to be set. And if my client wishes to waive, then I may contact the court and we may come in sooner than the exam to waive the exam. But I don't feel comfortable waiving without having reviewed the discovery with my client.
Okay, I'll send a date out. I'll suggest a date. Hopefully that's enough time. Let's see. How about June 15th?
Your Honor, I'm not in Michigan on the 15th. I'm gone the 14th, 15th, and 16th for work.
How about the 13th?
The 13th is fine with me. Mrs.
Sorry,
Davis?
Judge, I'm unavailable the 12th, the 13th, and the 14th.
What about June 9th?
June 9th, I'm in Muskegon, Your Honor, I apologize. Could we just continue the PCC for a shorter date?
Yes, Judge, this actually, this case, it might end in a resolution more than likely, after speaking with, Attorney Grant. However, I just cannot waive the exam without speaking with my client. But, with that in mind, I do believe that if we were to even set the exam either for the 19th or for the 8th, I can contact the court, at the top of the week, next week, if my client wishes to waive the exam.
So can you all do the 8th via Zoom?
Yes, yes.
I could do the 8th via Zoom, but I couldn't do it at 8:30. Could we do it more like 10 o'clock?
That's fine. We'll be here.
So for continued probable cause conference on the 8th at 10 o'clock, correct?
Correct. Yep.
Wonderful.
All right, sounds great, Judge. And I might actually be appearing either a little bit before 10 or a little bit after 10, as I will be driving at 10. So just giving the court a heads up, I'll be heading to a courtroom, but I will be able to appear by Zoom. I just might be a few minutes late if I'm parking.
Okay, that's fine.
Okay, thank you, and you all take care. Sorry.
Thank you very much. Have a lovely weekend.
You as well. And Ms. Torres Riddick, I will contact you by phone, the number that I have. So make sure that you answer the phone that I'm going to be calling from.
Okay.
Okay. And you have my number also. So if your phone goes voicemail, just give me a call, okay?
Okay. Do I have your number?
Did the
I
private
don't-
investigator give it to you?
I don't know. He didn't. He didn't
Okay.
give it to.
Judge, can you put me in a breakout room really quickly?
Sure. Okay, and Attorney Grant, have a good weekend.
Thank you.
Attorney Doc, good morning.
Good morning, Your Honor. I have a Miss Adriana Glenn.
Okay, are you waiving her presence or requesting to waive her presence today?
Yes, Your Honor. I think she's probably might still be in custody. So yes, yes, I am.
Okay. This is case 2357023, the people of the state of Michigan versus Adriana Glenn, charged with 1 count of home invasion first degree, set for a probable cause conference.
And it's Milwaukee P54828, appearing on behalf of the people.
And good morning, Your Honor, and Your Honorable Staff, Attorney Quentin Dox, P number 79657. On behalf of my client, Miss Adriana Glenn, Your Honor, I'm asking the court to waive her presence for the purposes of this hearing.
I will waive her presence. Do you have discovery?
Your Honor, I have not, to my knowledge, received discovery. I'm asking for like a 2-week PCC adjournment.
Let's see if discovery was provided. Mr. Milwaukee, was it sent over?
Paper was sent over on May 26th, digital on May 31st.
Yeah, Your Honor, on the light of that, I have not spoken with my client. I would like a chance to get the circumstances around these allegations and go over discovery, and then maybe decide what we can do after that.
How about 1 week for another PCC? And I want to put on the calendar the exam date 1 week from the PCC. So 2 weeks out for an exam and 1 week for PCC.
Yes, Your Honor.
So can you do June 9th for PCC?
I'll make it work, Your Honor.
And then exam date, I'm going to set it for June 16th. Can you do 9 o'clock?
Thank you, Your Honor.
Okay, so June 16th at 9 o'clock for the exam and June 9th at 8:30 for another PCC. Anything else? All right.
Not from the, you too, Your Honor. You have a good weekend. Thank you.
Attorney James, good morning.
Good morning, Your Honor.
How you doing today?
Is my client in the waiting room?
No, he's not here.
I gave him Judge King's Zoom login, so let me send him a different one. I'll come right back.
Okay.
Okay.
You talking to attorney, is he?
No attorney.
I got you.
The defendant's here?
Yes.
Okay.
Oh, Jesus.
I was waiting for that. Oh. That's the way he needs to bring. You said that, huh? You said that before, I didn't process it. So we could be happy to do the exam right now. You're right, he told us. You're right. Huh? Yeah, that- I called him on his check.
Okay, thank you.
Mr. O'Neill,
Yes.
ready, call the case, Attorney James?
Yes, Your Honor.
Is the people of the same mission? No, we can't, I don't have a court reporter. Give us a moment. Thank you.
Okay.
I'm so used to understanding.
I know.
Sorry.
Yeah.
Okay.
Yeah.
What do you got?
Can you hear me?
We're waiting for the court reporter, Mr. O'Neill. Okay, we're on the record with the people of the state of Michigan versus Michael Thomas O'Neill. Case 2357042. Mr. O'Neill's charged with count 1, assault with intent to murder, count 2, weapons, felony firearm, count 3, assault with intent to do great bodily harm less than murder or by strangulation, count 4, weapons, felony firearm, count 5, assault with a dangerous weapon, felonious assault, count 6, weapons, felony firearm, count 7, assault with intent to murder, count 8, weapons, felony firearm, count 9, assault with intent to do great bodily harm less than murder or by strangulation, count 10, weapons, felony firearm, count 11, assault with a dangerous weapon, felonious assault, count 12, weapons, felony firearm, count 13, weapons, firearms, possession by a felon, count 14, weapons, felony firearm, count 15, weapons, ammunition, possession by a felon, count 16, weapons, felony firearm, with habitual offender second offense notice, set for a probable cause competency appearances.
Edwin Sawadi, excuse me, Your Honor, P54828, appearing on behalf of the people.
And good morning, Your Honor. Nicole James appearing on behalf of Mr. O'Neill.
Mr. O'Neill, state your full name for the record, please.
Michael Thomas O'Neill.
Okay, Attorney James, do you have discovery on this case?
Judge, I have paper. If there's any digital, I do not have.
Digital was sent to May 31st.
Who did it come? Who did it come from? I'm sorry. When I search his name, I don't see anything.
It should be from evidence.com.
I'll search it and see if I can find it. If not, I'll let the court know.
Okay. All right, ready to set the exam date?
Yes, Judge. I'm gonna ask that it not be set next week, that it be set the following week.
Okay. Can you do June 15th?
What time?
10 o'clock, 10:30?
Your Honor, I'm sorry. This case may be going to a different APA, and she is not available 15th or the 14th.
Okay.
Thank you.
How about the 13th at 11?
It's good for us.
I think I can do that. Yes.
Okay. June 13th at 11 a.m. Mr. O'Neill, your exam has been set for an in-person preliminary examination at 36th District Court for June 13th at 11 a.m. You understand that?
Yes, ma'am.
Okay, so you are to be in person, not on Zoom, okay?
Hey, what time is it again, ma'am?
11 o'clock on June 13th.
Okay, thank you.
Thank you, Your Honor.
Welcome. Anything else to be the party?
Not at this time. Have a good one, everyone.
Log off, Mr. O'Neill.
I'm sorry, what'd you say, ma'am?
You can log off. You're all set for today.
Okay, thank you.
Thank you.
On the record, this is people of the state of Michigan versus Lee Lane Riley, 2355964. Mr. Riley is charged with one count of weapons carrying concealed, except for example. Appearances.
Alexander Kirker on behalf of the people, P86282.
Morning, Your Honor. May it please the court, Amir Magnet representing Mr. Legal Riley, present.
Mr. Riley, please state your full name for the record.
Good morning, Your Honor. My name is Malik Riley.
Okay, everyone ready forward?
Yes.
Yes, Your Honor.
Any preliminary matters?
None from the people, Your Honor.
If there's anyone on YouTube or Zoom who may be a witness on this case, now's your time to log off. Same if there's anyone in the courtroom who may testify today, now's your time to leave. Thank you for your first witness.
This time the people call Officer Deshaun Perry.
Your officer in charge.
Yes.
And what's this officer's name?
Sir Nicholas Hunt.
Harry.
Mr. Prox, what's your name?
Deshaun Perry. Officer Perry.
Make sure you speak into the microphone whenever you're ready.
Morning. Could you please restate your name for the record?
Deshaun Perry.
And are you currently employed, and if so, in what capacity?
Yes, police officer with the city of Detroit.
And how long have you been employed as a police officer?
A little bit over 3 years.
And were you employed as a police officer on March 13th, 2023?
Yes.
Did you in fact work on that date?
Yes.
Were you by yourself or with a partner?
Also a partner.
And what is your partner's name?
Officer Flannel.
And did your duties as a police officer take you from an area at or near 20040 Washington Nichols Road?
Yes.
It's in the city of Detroit, county of Wayne.
Yes.
And what brought you to that area?
I was providing special attention to consumers' liquor.
And what do you mean by special attention?
I was just providing police presence due to multiple shot spotters in the immediate area.
And did anything happen while you were conducting this special attention?
Yes.
And what was that?
I encountered Mr. Ross. So while providing special attention to consumers' liquor, I was driving into the parking lot. And I observed a male wearing a white hoodie walk to the driver's side of a vehicle parked in the parking lot.
And is the individual you encountered on that day present in the courtroom today?
Yes.
Could you please point out that individual and identify an article of clothing they're wearing?
He's wearing a nice suit sitting next to the defense counsel.
Your Honor, let the record reflect the identification of the defendants. And what did you observe about the defendant on this day?
As he walked to the driver's side of the vehicle, I observed what appeared to be the imprint of a firearm underneath his hoodie.
And could you describe what you saw?
I saw what I believe to be like the handle of the firearm pressed against his hoodie.
And upon observing what you believe to be the handgun of the firearm, what did you do?
I tried to gain the male's attention before he got to his vehicle, but he sat down in the driver's seat. Before he closed the door, I was able to get his attention.
And how were you able to get his attention?
By speaking to him.
And what did you say to the defendant?
I asked if he was a CPL holder. He said he was not. He stated that he wasn't armed, it was just his holster.
And in your experience, is it common for people to carry around empty holsters?
No.
Did this give you reason to believe the defendant was armed?
Yes.
Based on these observations, what did you do?
I exited the scout car and approached the mill. I performed a pat down of his right side. He was not firearm, he did not have a firearm on him.
Did you feel anything when you conducted this pat down?
Yes, empty holster.
Did you make any other observations at this time?
Yes, while speaking to the mill at the driver door, the door was open. And I looked inside and saw an empty personal size wine bottle on the seat.
And could you describe that wine bottle?
Yes, it was a Sutter Home, I'd say personal size wine bottle.
And did you say it was open?
Yes.
And what did you then do?
At that time, I had the male stand with my partner, Officer Flannel. I performed a search of the vehicle, recovered the bottle. Also, I recovered a firearm from the center council.
And could you describe the firearm you recovered?
Yes, I believe it was a black and silver Taurus in G2C name.
And just to clarify, you said this was in the center console?
Yes.
Was that between the front driver and passenger seat?
Yes.
Was this then within the reach of the defendant when he was in the driver's seat?
Yes.
Was there anybody else in the vehicle?
No.
And after recovering the firearm, what did you do?
I asked the male again if he's a CPO holder. He said he wasn't, and he was detained in handcuffs.
And did you conduct any further investigation of the firearm?
Yes. It was registered, personally, it was registered to Mr. Riley.
And did you issue any citations?
Yes, I wrote him a ticket for open alcohol. And we placed that open wine bottle evidence.
Was the weapon placed into evidence?
Yes.
Do you recall the evidence tag number?
If I saw my report, I would.
Or reviewing your report, refresh your recollection?
Yes, I believe it was 692-664-1, I believe.
You still like to review your report?
I would.
Has your memory been refreshed?
Yes.
Was that the correct evidence tag number you provided?
Yes.
I have no further questions, Your Honor.
No, there. Now, you're on the special detail at this liquor store in the city of Detroit. Is it common for you to just to be canvassing the people that are coming in and out of the liquor store when you're doing that special detail?
You say special detail?
Yes.
That wasn't a special detail. I was just patrolling.
Okay, you said that it was a special detail. You said something about you were paying special attention.
Yes.
Okay, so why special attention?
Oh, when I say special attention, I pull in frequently to liquor stores, gas stations, really just providing presence. When I say special attention, it's just me basically pulling into the parking lot, showing that we are patrolling.
Okay, is this liquor store part of the green light?
I'm not sure if it is. I don't believe so.
All right. Now, when you observed the individual that walked out of the liquor store, where were you? Were you in your police vehicle?
Yes, I didn't see him walking out of the liquor store. I seen him walking towards the driver door of the vehicle.
So he was in the parking lot?
Yes.
And you were in your police vehicle at that point?
Yes.
Okay. How far away were you at that time from the individual that was walking towards the car?
maybe 15 feet, maybe, I'm not sure.
And so in 15 feet, you indicated that you saw what you thought was maybe a bulge of a handgun, is that right?
Yes.
Okay, now, were you able to see the handgun or anything as part of that? Or just something over?
So I saw what I believe to be the imprint of a firearm.
Right, was that with the clothing, article of clothing around a firearm, or were you able to see something on his hip?
No, just on top of it. The
clothing was on top?
Yeah.
So the clothing was covered, and you thought maybe something could be concealed under?
Yes.
Okay, I understand, all right. So then you approached the vehicle on foot?
In my car.
You pulled up to him in your car? All right, is that a yes?
Yes.
And the individual hadn't gotten into his vehicle yet and closed the door?
He sat down in the vehicle, but he hadn't closed the door yet.
All right, and that's when you engaged in some form of a conversation with him?
Yes.
All right. And you asked him if there was a CPL. At what point did you get out of your vehicle to talk to Mr. Riley?
I asked him, was he a CPL holder? He stated no.
Did you do that while you were seated in the car?
Yes.
Okay. Then you stepped out of the car to pat him down?
Yes.
Okay, and you didn't find a weapon on his person?
Not on his person.
Okay. And you found an empty bottle of wine, you said, right?
On the driver's seat, yes.
Okay. Which then, at that point, you began to do a search of the motor vehicle, is that true?
Yes.
Okay. Mr. Riley never consented to the search of the motor vehicle, is that true?
Yes.
Okay. And you never asked for consent to search, did you?
I think I did.
And he said no?
I believe so.
Okay, but you searched anyways?
Yes.
Okay. And so at that point, that's when you began to rummage through the motor vehicle, and what you ultimately find in the center console is the handgun, is that right?
After I observed the open long bottle, I went to the vehicle, yes.
Okay. Now, the empty wine bottle, is that what you believe is your probable cause to search a vehicle?
Yes.
Okay. And so why did you search a motor vehicle? Because you saw an empty wine bottle. Do you think there was going to be evidence further of a crime?
I thought it was going to be more open alcohol inside the vehicle, yes.
Okay, but you didn't see any other open alcohol bottles in your immediate view, is that correct?
In my immediate view, no.
So nothing was in plain view to determine or say to you that there could have been more open bottles, is that right?
Just that one bottle.
Okay, and that was the empty bottle you saw?
Yes.
All right. And so an empty bottle is a crime?
So it wasn't completely empty, first of all.
Hold on now, wait a minute now. You said empty 3 or 4 times.
Okay, that's my fault, I didn't clarify, but it's partially empty.
See, that's a big distinction, sir. What do you mean by partially empty? Do you have a picture of the wine bottle?
Just place on evidence.
Where is it?
I don't have it.
Do you have a photograph of it?
I don't know.
Having an empty wine bottle. Were you arresting this individual for possession of open intox?
She's gonna be detained until we figured out how much of open alcohol inside the vehicle.
Okay. So he wasn't being arrested?
That's just a citation. If anything, I was take the wine, put on evidence, issue him a citation.
Okay. So the purpose of your search of the motor vehicle wasn't because you were arresting him and you needed to inventory the vehicle then at that point?
Correct.
So that's not the reason why you wanted to search, correct?
I was gonna issue him a citation for the open wine bottle he had. So I wasn't sure if he had.
Did you put him in handcuffs?
No, he's detained with my partner standing next to him.
Was he handcuffed?
No, he was not.
So he was outside of the motor vehicle?
Yes.
I told you don't search the car, you searched the car anyways?
Yes.
All right. And you weren't gonna arrest him for the wine?
Issue him a citation. I was not gonna arrest him.
Okay. I have no other questions, Your Honor.
No.
Any other witnesses?
No other witnesses to the vehicle.
No defense witness.
Mr. President, whenever you're ready.
Your Honor, at this time, the people would move to bind over the defendant on count one, weapons carrying concealed. As we heard from Officer Carey, officers at this time were providing special attention to consumers' liquor. As Officer Perry describes, providing police presence to areas which crimes have recently been committed. This time he observed an individual who he identified as the defendant with what he believed to be an imprint of a handgun, or at least the handle of a handgun pressing against the sweatshirt that the defendant was wearing at the time. Officers then pulled up in the scout car. Officer Perry said he could not initially get his defendant's attention until the defendant stepped into the vehicle, at which time officers drove up with the scout car and asked the defendant if he was a CPO holder, which the defendant said no. When the officers got out of the vehicle, and Officer Perry spoke to the defendants. While speaking to the defendant outside of the vehicle through the open driver's side door, Officer Perry said it's observed an open Sutter Homes personal size wine bottle in the center console. Officer Perry at this point then searched the vehicle, believing to find possibly more open containers within the vehicle to conduct further investigation based on the probable cause of seeing an open, partially empty bottle within the reach of the driver of the vehicle. This time, Officer Perry recovered the partially empty wine bottle and also a firearm from the center console, which he described as a silver and black Taurus G2C. And as he stated, it was within the reach of the driver of the vehicle at the time, and there were no other occupants in the vehicle. The weapon was then placed into evidence and the defendant's hands, as well as he was issued a citation for the open container of personal size wine bottle that was recovered as well. So people believe they've met the burden of probable cause and moved to bind over the
Right. There's no consent to search the motor vehicle. The wine bottle was testified on direct examination, on cross-examination, that it was an empty bottle. When I pressed him to determine if this empty wine bottle was a crime, he then changed his statement and said, oh, it might have been partially, had some partial liquid in it. Either way, Your Honor, he said he wasn't going to arrest him for the wine bottle. And so the search becomes a consent issue. It's not a search incident to arrest. It's not an inventory search. It's whether or not he had the right to go into that motor vehicle without consent, and he did not. It doesn't fall into the exceptions of any of the Fourth Amendment rules for the motor vehicle exception. He needed to have consent from the driver. He did not search the vehicle anyways. So anything that's found in that motor vehicle is through the choice in the street. I ask the court to deny the bind over, dismiss the case.
Officer Perry testified, and I won't go through all the facts. He thought, or what he thought was imprint of a handgun. At this point, Officer Perry was allowed to ask questions based on Terry. The defendant then sat in his car with doors still open. Officer Perry asked if the defendant had a CPO, which the defendant said no. At this point, Officer Perry, what I heard, no longer do anything else. However, the defendant then stated that he was just carrying a holster. So based off of that, Officer Perry testified that he asked or had him step out of the vehicle, patting him down. Holster is specifically associated with the gun, doesn't mean that a gun is present, but I do believe now that Officer Perry had that information. He has had some reasonable suspicion that the gun is. After patting down the defendant, we found a holster. He said that in plain view, he observed on direct what happened, what wasn't open in tox or a bottle with Sutterholm wine. On cross, he stated that it was half empty. Now it's credibility in it. And based off of that observation, Officer Perry then advised his partner, who then searched the vehicle, retrieved the wine bottle, and also proceeded to search the vehicle and find a handgun in the middle console. Case law says the Terry search need not be limited to a stop and frisk of the person, but may extend as well to a protective search of the passenger compartment of a car. If an officer possesses a reasonable belief based on specific and articulable facts that the suspect is dangerous and may gain immediate control of weapons. I think this is going to be a question of fact for the trier facts to whether or not the very limited facts here are articulable and specific. Gun holster, as well as the statement from the defendant that had a holster on his pocket or his hip, and also the question about whether or not the liquor bottle or the wine bottle was empty or half empty. It does raise a question of credibility from Officer Perry as far as whether the wine bottle was empty or not, but not enough for me to dismiss at this stage based off of people videos. So with that, I'm going to invite you over, sir, for bring on the information date. It'll be 2 weeks from today, June 16th at 9:00 p.m. Frankfurt College.
Thank you.
Sorry. Attorney Hamilton, I'll adjourn the PCC with the exam day on it.
Okay, that works.
How much time do you want for PCC? A week? Does a week work, for an
Oh.
adjourned PCC?
Yes, that works. Sorry, I couldn't hear you.
Oh, you know what, I can't hear that one either. Let me turn it on. You come back on the 9th?
Yes,
Okay. I want to put an exam on the books, because otherwise it'll be another 3 weeks from today, if I don't put it in the calendar.
okay. All right, thank you.
June. Can you do June 20th at 9 o'clock?
Yes, I can do that.
Okay, all right. Do you want to go on the record?
If we need to, sure.
No, we don't need to.
No, then I'm all good.
All right, have a good weekend.
Thank you. You too.
I can't tell you, I don't know. Just kidding.
Yeah.
It's a secret. Samuel Parker. Yeah, well, okay, we are on the record as the people of the state of Michigan versus Michael Marcel Price Jr. This is case 2356741. Mr. Price Jr. is charged with count one carjacking, count two robbery armed, count three weapons carrying concealed, count four and five weapons felony firearms set for an exam today. Appearances.
Alexander Kirker on behalf of the people, P 86282.
Good morning, Your Honor. Stephanie Carson on behalf of Mr. Price, P570996.
Mr. Price, can you state your full name for the record, please?
Mike Marcel Price Jr.
Good. Okay, today's the day set for an exam. I have a waiver form signed this morning. Is it correct, Attorney Carson, your client is waiving his exam?
Yes, Your Honor, that's correct.
Okay. Mr. Price, I'm going to ask you some questions. If you don't understand me or if you can't hear me, let me know, okay?
Okay.
And make sure you speak up for the court reporter, okay?
Is that a yes?
Yes.
Okay. Is it your wish to waive your preliminary exam today?
Yes.
You understand that you have a statutory right to an exam?
Yes.
And that if you were to demand that exam today, the people would have to show at the probable cause standard, which is a lower standard of criminal law, but still a standard, that those charges that I read off were committed in the city of Detroit and that you probably committed those crimes. You understand that?
Yes.
And that by waiving your exam today, that means that the people do not have to present any evidence or provide any testimony today regarding those matters. You understand?
Yes.
You also understand that you are not giving up your right to trial.
Yes.
Knowing that information, do you still wish to waive your exam?
Yes.
Did anyone force you or threaten you to waive your exam? Did anyone promise you anything? Okay. Any objection from the people?
No objection, Your Honor.
Okay, I find your waiver to be freely, understandingly, and voluntarily given. You'll be bound over to Third Circuit Court, Frank Murphy Hall of Justice. Since you're in custody, your arraignment will be 1 week from today, so June 9th at 9 o'clock. Anything else from either party?
Your Honor, may I please have a DSU referral? So
Yes.
I can address bond with the circuit court.
Okay.
Thank you.
You're welcome.
All right, Mr. Price, I'll
Off
see
the
you.
record on Price. Attorney Marshall, good morning.
Good morning.
Okay, we're adjourning this, correct?
Correct.
Okay. You have a date in mind, or do you have a date in mind?
We could do it tomorrow.
Oh, no, we're not gonna be here tomorrow.
I'm just teasing. It's a big, huge file that was sent to me. I think I'm gonna have to go get an external hard drive to download it, so at least a couple weeks,
Okay.
maybe more. If that's okay. He's out on bond.
How about June 15th?
No, that's a horrible day. Could do June 19th, later in the morning.
We're closed that day.
Mm, Jam the heck up. How about, you said June 16th, I've got an 8:45 and a 9 over at Frank Murphy. I could pop over later.
I can't do after 10 o'clock on June 16th.
Oh, okay. 19th it closed. I'm just all backed up with trials. I'm really sorry. Do you mind if we go into July?
That's fine.
How about July 6th, first thing in the morning?
9 o'clock?
9 o'clock? Okay.
Yep. All right. See you then. Unless you want to go on
Thank
the
you.
record. All set.
Okay, thanks.
Good weekend.
Have you too.
Yeah.
Six.
Yeah, well.
Oh, yeah. I got it. But you had all together. Okay. Ready, Staples?
Right here.
Good morning.
Good morning, Judge.
Case 2356950, the people of the state of Michigan versus 7. Involved Staples, charged with count 1, weapons, firearms, possession by felon. Count 2, weapons, felony firearms, second offense. Count 3, weapons, firearms, possession by felon, second offense. Count 5. I don't know if I said count 4, weapons, felony firearms, second offense. Count 5, weapons, firearms, possession by a felon. Count 6, weapons, felony firearms, second offense. Count 7, weapons, firearms, possession by a felon. Count 8, weapons, felony firearms, second offense. Count 9, weapons, firearms, possession by a felon. Count 10, weapons, felony firearms, second offense. Notice. Count 11, 12, 13, 14, and 15, weapons, ammunition, possession by a felon, habitual offender, fourth offense. Notice that for an example, appearances.
Anyone to walk, keep by 488.
May it please the court, Neighborhood Defender Service of Detroit by Jeffrey Konecki, P 64800, on behalf of Mr. Staples. Mr. Staples, please state your name for the record.
Ted Staples.
Good morning.
Yes, Your Honor.
Yes, Your Honor.
Any preliminary matters?
Yes, Your Honor. People's proposed exhibit 1 is certified register of actions from the Third Circuit Court, case number 12-004-604-01-H. This indicates that Mr. Staples pled guilty to a weapons firearm possession by felon on July 13th, 2001.
That you have had opportunity to look at that?
I have, Your Honor, and so stipulated for exam purposes.
May I approach you?
Yes, it will be admitted as exhibit 1. People's exhibit. Anything else?
No, Your Honor.
No, Your Honor.
Okay, if there's anyone on YouTube or Zoom who may be a witness in this case, now is your time to log off. Same. If there's anyone in the courtroom who may testify today or in the future, now is your time to leave the courtroom with that.
First witness, Your Honor, is Brandon Shortridge.
This way, sir. Doors right in the front, and you might have to pull that microphone down.
Thank you, Judge.
Your occupation for the record, please.
Brandon Shortridge, I'm a sergeant with the City of Detroit Police Department,
How long have you been with the Detroit Police Department?
18 years.
And were you on duty May 15th, 2023?
Correct.
Were you on duty in the area of 16144 Carolyn's Street, Detroit, and City of Detroit, County of Wayne?
Yes.
When were you in that area?
I was there with my crew to execute a search warrant.
And did you execute that search warrant?
Yes, I did.
When you arrived, what occurred?
When we arrived, I had assistance from the tactical service sections. They actually executed the search warrant for my unit. My unit is more of an investigative. Made the location. TSS detained 2 people. They were brought to the front yard where I stood with 2 people while they secured the location. Once the location was secured, both people were brought back into the location and staged in the front room of the location.
Is one of those persons in this courtroom today?
Yes, he is.
And could you give us location and describe a piece of clothing that he may be wearing?
It's Mr. Staples. He's in the front row in black and white checkered shirt.
Let the record reflect that the officer has identified the defendant. What occurred, once you entered the building, what occurred?
So I assisted with the search of the residence. I made the 2nd floor bedroom.
Okay. Could you explain where that bedroom was?
So it would be the 2nd story. On the 2nd story of the house, the only thing up there is a bedroom and a hallway.
And did you search the bedroom?
Yes, I did not make multiple recoveries.
What exactly did you recover?
In the closet of the bedroom, there were a clothes rack with male clothes hanging in the racks. I recovered, I believe it was a black 6-hour handgun. And then on the floor of the closet, I recovered a sawed-off shotgun, 2 rifles, AR style pistol, which was 5.56 caliber handgun, and a 1 pistol, AR pistol, 2 rifles, and a shotgun. All of them were loaded except the shotgun.
Did you find anything else?
Yes, I did.
Related to weapons?
Yes, I did. In that same closet, there was a box with miscellaneous 40 caliber ammunition and 22 caliber ammunition. And while searching, after I had observed that search, I moved to the bed area where I found a bag with Mr. Staples' state of Michigan identification card and social security card in the bag.
Before you move any further, the officer in charge of steps. I believe.
I thought when you were talking as a witness. What's your name, officer?
Martin.
Okay, yeah. No, he's the officer in charge. I have no objection to the state. I may call him depending on how this should, but I have no problem with joining the state.
All right.
Did you find any other type of ammunition?
Believe that was the, if I recall correctly, I believe it was all the ammunition.
I'm sorry.
If I recall correctly, I believe that's it.
Your Honor, I have nothing else for this witness.
Sergeant Shortridge, correct?
Yes, sir.
Okay. Sergeant Shortridge, you indicate you were there to serve a search warrant, correct?
Yes, actually, sir.
Were you in the applicant on the search warrant?
Am I the applicant? No, I am not the applicant.
Were you involved in the initial investigation that began on May 9th?
Not on May 9th, no.
Okay. When did you get involved in this case?
I was advised by a sergeant prior to that. I believe it was either that night or the next morning of an incident that occurred in that location.
So the night of,
It was either that night afterwards, a few hours, or the next morning. I'm not exactly sure.
okay, the 9th or the 10th, roughly?
Yes,
Okay.
correct.
Just to make sure we're talking about.
Yes,
okay.
correct.
So you were given information, but you weren't part of the investigation until you served the search warrant, correct?
Yes, correct.
Okay. You indicated there were 2 people in the house, correct?
That is correct.
Okay. And when you entered the house, where were the individuals?
I believe, they were,
Do you know? I'm not asking.
I don't know where they're at inside the house.
When you saw them, where were they? First.
Coming out the front door.
Okay, someone else was bringing them out, another officer was bringing them out?
Correct.
Okay.
TSS was bringing them out.
Okay, so then you saw them and you stood by them outside, correct?
Correct.
After it was cleared, they were brought in,
Correct.
and then you were part of the search?
Yes, sir.
Okay. You never saw Mr. Staples in the room upstairs?
I did not.
You didn't see him anywhere but coming out of the front door and outside, and then where you put him back in, is that fair to say?
That's correct.
Okay. Did you talk with Mr. Staples while you were there?
I believe I talked briefly, initially when he came out the door.
Okay, did you Mirandize him or ask any questions regarding the investigation?
No, I did not.
Okay, thank you, nothing further.
Can you read your right?
No, Your Honor.
Okay, Sergeant Shortridge, you all set.
Thank you, Judge.
I no further witnesses, Your Honor.
Okay. Next witness.
Yes, Your Honor, I'd like to call Officer Martin, the officer in charge on the case, please. Ready for it?
Okay, have a seat, make sure you speak up in the microphone. If you're ready to turn.
Thank you, Your Honor. Officer Martin, are you familiar with the case of the people of the state of Michigan versus Kevin Staples?
Yes, sir.
Okay, are you the officer in charge of it?
Yes, sir.
All right. Were you the applicant on the search warrant for that case?
Yes, sir.
Okay. Did you, did you respond or go to that area on May 9th, the week before the search warrant?
No, sir.
Okay. So all the information that you have about from that night was from reports of other officers and that information, correct?
Correct, and, like speaking with, Officer Shortridge or Sergeant Shortridge, who informed me, hey, this is what was going on here.
And so that information you got after the search?
Correct.
Okay. But I'm saying before the search warrant, you gathered the information and then submitted the affidavit for the search warrant, correct?
Correct.
And the information that you used was information for your officers and then also shot spotter technology, is that correct?
Yes, sir.
Okay. And the shot spotter put something in the area of that address, is that correct?
Correct.
And then, but you indicate that when you submitted that, the shot spotter, can pinpoint the precise location within 25 meters or 82 feet, correct?
Correct.
So did you eventually go to the Tireman address?
Yes.
Are there other houses around the Tireman address?
Yes, sir.
Okay. And there are houses that would be within 82 feet, correct?
Yes, sir.
There's sidewalks that would be within 82 feet?
Yes, sir.
Backyards, alleys?
All the above.
All the above, fair enough, okay. And no civilian witness gave you any information regarding seeing a shooting or hearing a shooting, correct?
To me, no. I don't know, in the report, there might have been some mention of, talking to neighbors, but.
Thank you. Nothing further.
And nothing more.
Thank you.
My apologies for being late this morning.
Any other defense witnesses?
No, I'm sorry. No, Your Honor. That's right.
Your Honor, people move to bind over the defendant on all charges, with the exception of few of the ammunition.
Associated with the shotgun?
No, I think the shotgun was, right, the ammunition, only count would be, 40 caliber. Yes, it's only 14, 15, 13, 12, and 11, with no testimony indicating that caliber, ammunition. Otherwise, we ask for bind over on all charges and reserve argument.
Okay, so.
I'm just few more questions.
And I didn't help you either, so please down the record which counts you are not asking to be done.
Okay, count 11, count 12, count 13, and count 15.
Those are the ones you're not requesting by. Just on 14, okay.
Just 14 is
Okay.
40 millimeter caliber. And with that, we'll reserve further argument.
Your Honor, my argument's going to be based on they went to serve a search warrant, so issue with Sergeant Shortridge isn't the issue, it's officer in charge who they followed a shot spotter. The only information they had was shot spotter and then police information that they had, and that was sufficient for them to get a warrant to search this home that was potentially within 82 feet of a possible shot that was fired. That's the basis of the information that they have that's been presented to the court on a search warrant. That's it. So with that, they have the ability to go in and raid someone's home and go and drag them out and search through all of their stuff based on a shot spotter that can get no closer than 25 yards. Can't get any better than that. There's plenty of houses, alleys, streets, anything could have happened with that. There's no connection to that house that they've been able to establish here that would have allowed them to get a search warrant. So we believe that the search warrant is invalid, hence the search after is invalid.
Your Honor, we feel that the search warrant is valid and is reviewed and signed by a magistrate and duly acted upon, and when it was duly acted upon, said weapons were found and found in a room controlled by the defendant, his social security card and his,
I'm sorry, I have to object. Controlled by the defendant is a mischaracterization. They indicated that no one ever put him in that room, said he was in that room, saw him in that room. They saw him downstairs. There was stuff in that room, but I don't think that they can say that he had control. There's no evidence for testimony for that.
Your Honor, his driver's license and social security number, those are two things, especially his social security number, he did not allow. He flying around, plus, the officer testified, that he also saw men's clothes in there. It's obviously, it's question, if nothing else, it's a question of fact for the trial. And we asked, for the bind over on the charges. Thank you.
Okay, at this stage, I do believe that people have met for issues probably cause and we'll say just because it's signed by a magistrate doesn't mean it's necessarily done correctly as far as search warrant. I believe that search warrant issue that raised attorney connected, maybe to an evidentiary hearing. Get into the specifics of the search warrant, I've seen the evidence of running review one. So at this time, I do believe that people have met for approved for counts 1 through 10, as well as count 14, along with or with the evidence that although the defendant was not in the room at the time that the officers found the 5 different weapons, 6-hour sawed-off shotgun, AR-style pistol, 2 rifles, and ammunition attached to all but the sawed-off shotgun. There was in that second floor bedroom a male clothing as well as bag with the defendant's ID and social security number. I do believe that's enough to raise the question of fact for a trial fact. So I will have you bound over, Mr. Staples. Your arraignment on the information date will be 2 weeks from today, since you're out of custody. It will be June 16th at 9:00 a.m.
Thank you, Your Honor.
Have a good
People of the State of Michigan versus Christopher Brandon Scott. Mr. Scott is charged with one count of weapons carrying concealed, except for example, Harrison.
Hey, what is the Milwaukee P5488, hearing on behalf of the people?
Good still morning, Your Honor. Jeffrey Schwartz, P32076, on behalf of Mr. Scott. Give your name, sir.
Scott Brandon.
Your Honor, we've had an opportunity to discuss the right to a preliminary examination and the burden of proof that the prosecutor must present in order to meet the burden. He understands that, wishes to waive the same, and is ready to be questioned by the court.
Any objection from the people?
No objection, Your Honor.
Okay, Mr. Scott. You want to ask me some questions if you can't hear me or if you don't understand, you let me know, okay? You have to say yes or no for the court order, okay? Did you wish to waive your preliminary exam today? You understand that you have a statutory right to exam? Can I speak a little bit louder? And then if you were to demand that exam today, the people will have to show at the probable cause standard, which is a much lower standard in criminal law, but still a standard, that one charge I read off was committed in the city of Detroit and then you probably committed that crime. Do you understand that?
Yes.
And then by waiving your exam today, that means that people do not have to present any evidence or bring witnesses before you today to prove anything. You understand that?
Yeah.
You also understand you're not giving up your right to trial.
Yes.
You have a question about that? You have to say yes or no.
No.
Okay, did anyone force you or threaten you to waive your exam?
No.
Did anyone promise you anything?
No.
Okay, I find your waiver to be freely, understandingly, and voluntarily given. Since you're out of custody, your arraignment on the information day will be exactly 2 weeks from today, June 16th at 9:05 a.m. Frank Murphy Hall of Justice, okay?
Very good. Thank you, Your Honor.
Thank you, Your Honor.
Have a good weekend, and we'll execute the waiver.
Okay, and thank you for dressing up the court. To be surprised how many people don't.
Just stay right there. I'm gonna have you sign a paper.
Thank you, Your Honor.